Have you ever wondered who is truly at fault in a car collision? What if a minor is driving, or if the vehicle belongs to someone else, who bears the responsibility then? Understanding the legal obligations in car collision cases in the Philippines is crucial, not just for drivers, but for anyone who owns a vehicle. Car collisions are an unfortunate but common occurrence on the roads, and when they happen, determining liability can become a complex legal issue. In the Philippines, the law provides specific guidelines to ascertain who should be held accountable in these situations. Whether you're a driver, a vehicle owner, or even the parent of a young driver, understanding these legal obligations is important for protecting your rights and ensuring that justice is served. Before we dive into the details, don't forget to hit the subscribe button so you can stay updated on our latest content covering essential legal topics. In the realm of Philippine law, the liability of parties involved in car collisions is primarily determined by the principles of tort law. Under tort law, individuals are responsible for the damages they cause to others, whether through direct actions or omissions. This responsibility is known as quasi-delict and is enshrined in Article 2176 of the Civil Code of the Philippines, which states that any person who, by act or omission, causes damage to another, with fault or negligence, shall be obliged to pay for the damage done. Relevant legal provisions. One of the key legal provisions relevant to car collisions is Article 1903 of the Civil Code. This article addresses vicarious liability, where certain individuals can be held liable for the actions of others. For instance, vehicle owners can be held responsible for damages caused by a vehicle driven by a family member, especially if the vehicle was used for family purposes. Moreover, parents can be held liable for the negligent acts of their minor children. Article 2180 of the Civil Code further expounds on this concept, stating that the obligation imposed by Article 2176 is demandable not only for one's own acts or omissions but also for those of persons for whom one is responsible. This means that employers can be held liable for the negligent acts of their employees, and parents can be held liable for the acts of their minor children.
To better understand how these principles are applied, let's look at the landmark case of Narciso Gutierrez versus Bonifacio Gutierrez et al., GR number 34840, 1931. This case is pivotal in Philippine jurisprudence for establishing multiple levels of liability in car collision cases. A. Owner's liability. In this case, the Supreme Court held that the owner of a vehicle can be held liable for damages caused by a family member who was driving the car. The reasoning behind this is rooted in the idea that when a vehicle is used for family purposes, it is essentially within the scope of the owner's business. This means that if a family member causes an accident while using the vehicle for any family-related activity, the owner could be held liable for the resulting damages. B. Parental responsibility. The case also emphasized parental responsibility under Article 1903. The court found the father liable for the damages caused by his minor son, who was negligently driving the family car. This is a clear application of the principle that parents are responsible for the acts of their minor children, especially in cases where the child's actions result in harm to others. C. Driver's liability. Despite the focus on the owner and parental liability, the court did not absolve the driver of the vehicle from responsibility. The driver, in this case, was also held liable for his own negligence. The ruling underscores that liability can be shared among multiple parties, the driver for their immediate actions, and the owner or parent for their indirect responsibility.
D. Multiple party liability. In Narciso Gutierrez versus Bonifacio Gutierrez et al., the court also dealt with the concept of multiple party liability. The case involved two vehicles, and the court found both the family owning one car and the owner and driver of a truck involved in the collision jointly and severally liable. This means that all parties were considered responsible for the damages, and the injured party could recover the full amount of damages from any of the liable parties, who would then have the right to seek contribution from the others. E. Contributory negligence. The principle of contributory negligence was also considered in this case. The court looked at the actions of both drivers as they approached a narrow bridge, which led to the collision. Contributory negligence occurs when the injured party is found to have contributed to the harm they suffered through their own negligence. In such cases, the liability of the offending party may be mitigated, and the damages awarded to the injured party could be reduced accordingly. Given the complexities surrounding liability in car collision cases, here's something to ponder. If a driver is found to be only partially at fault in a collision, should the liability of the vehicle owner or parent be equally diminished, or should they still bear full responsibility under the law? Share your thoughts in the comments below.
Understanding the legal obligations in car collision cases is not just about knowing who to blame, it's about ensuring that the rightful parties are held accountable and that victims receive the justice they deserve. Whether you're a driver, a vehicle owner, or a parent, these principles are crucial for navigating the legal landscape in the event of an accident. If you found this video informative, make sure to subscribe to our channel for more content on legal issues in the Philippines. And don't forget to comment below with your thoughts on today's discussion. We'd love to hear your perspective on the question we posed.